Trademark Act, 1999. Questions and answers. Q. 1. How is the Trademarks Act 1999 different from the Trade and Merchandising Marks Act 1958? Ans. Enactment of the Trademarks Act 1999 is a big step forward from the Trade and Merchandise Marks Act 1958 and the Trademark Act 1940. The newly enacted Act has some features not present in the 1958 Act, and these are: 1. Registration of service marks, collective marks and certification trademarks. 2. Increasing the period of registration and renewal from 7 years to 10 years. 3. Allowing filing of single application for registration in more than one class. 4. Enhanced punishment for offenses related to trademarks. 5. Exhaustive definitions for terms frequently used. 6. Simplified procedure for registration of registered users and enlarged scope of permitted use. 7. Constitution of an appellate board for speedy disposal of appeals and rectification applications which at present lie before High Court. Q. 2. Explain the meaning of trademark. Ans. In general parlance, a trademark is a visual symbol in the form of a word, a device or a label applied to goods for purpose of indicating their trade origin. According to Section 2, 1, ZB, trademark means a mark, capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others. And may include shape of goods, their packaging and combination of colors, and used to indicate to a connection between the goods or services and some person having the right in the course of trade in relation to goods or services, either as proprietor or permitted user. And includes a certification trademark or collective mark. Thus, a trademark may be defined as a visual symbol or representation or any specific identification by way of any identification mark, word or label so as to distinguish the goods or services from the other goods and services. It may include shape of goods, their packaging and combination of colors. It must be used in relation to goods or services. A trademark thus indicates to public that the goods or services carrying a specific trademark are being sold by a particular businessman and that person has an exclusive right to sell his products under that trademark. The definition of trademark under the Trademark Act is not very exhaustive. Various judicial decisions have elaborated upon the term trademark as follows. In Lakshmikant V. Patel vs. Chetan Bhai Shah, 2002 PTC 126 SC, the Supreme Court held that mark includes name or word also among the other things as defined in the Act, and name may also include an abbreviation even. Q. 3. What are well-known trademarks? Ans. The term well-known trademark has been for the first time defined by the 1999 Act, and S2, 1, G, defines that well-known trademark, in relation to any goods or service, means a mark which has become so to the substantial segment of the public which uses such goods or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to the first mentioned goods or services. Q. 4. What is the meaning of service in the Trademark Act 1999? Ans. Service means service of any description which is made available to potential users and includes the provision of services in connection with business of any industrial or commercial matters such as banking, communication, education, financing, insurance, chit funds, real estate, transport, storage, material treatment, processing, supply of electrical or other energy, boarding, lodging, entertainment, amusement, construction, repair, conveying of news or information and advertising. Q. 5. How are the terms certification trademarks and collective marks defined in the Act? Ans. According to S2, 1a, certification trademark means a mark capable of distinguishing the goods or service which are certified by the proprietor of the mark in respect of origin, material, mode of manufacture of goods or performance of service. The term collective mark has been for the first time defined by the 1999 Act, and S2, 1g, defines that collective mark means a trademark distinguishing the goods or services of members of an association of persons, not being a partnership, which is the proprietor of the mark, from those of others. Q. 6. What are the essential conditions of a trademark? Ans. An ideal trademark should be easy to speak, remember and spell. It should be small, simple and attractive and suggests the desirable qualities of the goods or services. It should be different from other trademarks of same class and should be registerable. In order to bring it within the scope of statutory definition, a trademark should satisfy the following essential requirements. A. It must be a mark. As per Section 2 meters, mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging or combination of colors or any combination thereof. B. It must be used or proposed to be used in relation to goods which are subjects of trade or manufacture or in relation to services. Sec 2, 1, ZB. C. Any reference to the use of a mark shall be construed as a reference to the use of printed or other visual representation of a mark. D. A trademark should be present at the time of sales of goods and not when the goods are put to use. A. It gives distinctiveness to goods and services. Distinctiveness is the essential feature of the trademark. Distinctive character means a characteristic of goods or services which is capable of distinguishing them from the goods or services of another person. It is also essential that trademark is used in the course of business or trade. In the case of Santosh Devi vs Ramesh Kumar, 2007, 34, PTC 219, Raj. The HC held that where a business has been closed for a long time and there is no loss to the goodwill or reputation of the business, a new entity using the same old name cannot be debarred to do the business in the old trade name. Q. 7. What do you mean by deceptively similar marks? Ans. One of the important questions that frequently arise for consideration in trademark law is whether two trademarks are deceptively similar. According to Section 2(h), the term deceptively similar means a mark shall be deemed to be deceptively similar to another mark if it so nearly resembles that other mark as to be likely to deceive or cause confusion. Nature of deception or confusion. Deception or confusion may arise in the following ways. I. Deception or confusion as to goods. A person may buy the goods seeing one mark thinking that it is the brand which is in his mind but in fact is not the same. This is the most common type of confusion or deception. E. Deception or confusion as to trade origin. A person at a mark may buy goods thinking that it is coming from the same source as some other goods bearing a similar mark which he is familiar with. E. Deception or confusion as to trade connection. A person looking at the mark may not think that it is the same as one with a different brand in his mind, but the similarity may make him believe that the two are in some way or other connected with each other. Q. 8. Explain the principles for deciding the questions of deceptive similarity of two marks. Ans. Some principles regarding the comparison of marks could be summarized as below. A. The main idea or salient features of the mark must be considered. B. Marks must be looked at from the view and first impression of a person of average intelligence and imperfect recollection. C. Words must be compared as a whole. When comparing two words, it is not right to take a part of word and to compare it with a part of the other word. One word must be considered as a whole and compared with the other word as a whole. Marks must be compared as whole, microscopic examination being impermissible. In Coca-Cola Company of Canada vs. Pepsi-Cola Company of Canada Limited, 1942-59, R.P. C. 127, it was found that cola was in common use in Canada for naming the beverages. The distinguishing feature of the mark Coca-Cola was Coca and not Cola. For the same reason, the distinguishing feature of the mark Pepsi-Cola was Pepsi and not Cola. It was not likely that anyone would confuse the word Pepsi with Coca. D. Similarity in structure, sound and idea. Overall structural, appearance, and phonetic, sound, similarity is relevant for consideration. Further, it is necessary to take into account the meanings conveyed by the words or the ideas suggested by them. For words are remembered not only by their sound and appearance but also by the ideas suggested by them. Words conveying the same meaning or suggesting the same idea are in general likely to cause confusion. In Bombay Oil Industries Private Limited vs. Ballarpur Industries, Air 1989 Delhi 77. Delhi High Court held that use of trademark, SHAPOLA, for edible oil which is similar to registered trademark, SHAFFOLA, is an act of infringement as both are edible oil and of same nature. Both are phonetically similar also. A. Distinguishing or essential features to be considered. It is impossible to accept that a man looking at trademark would take in every single feature of the mark. The broad and salient features must be considered, for which the marks must be placed side by side to find the differences in the design. F. Surrounding circumstances to be considered. In addition to the nature of commodity, class of purchases, the mode of purchase and the other surrounding circumstances must be considered. Q. 9. Explains the grounds on which registration of a trademark can be refused. Uns. Sections 9, 11 and 12 provide various grounds on which registration of trademark can be refused. A. Absolute grounds for refusal of registration. As per Section 9, following categories of trademarks shall not be registered. A. Which are devoid of any distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person. B. Which consist exclusively of marks or indications which may serve in trade to designate the I, kind, quality, quantity, intended purpose, values, geographical origin, or E. The time of production of the goods, or E. Rendering of the service, or IV. Other characteristics of the goods or service. C. Which consist exclusively of marks or indications which have become customary in the current language or in the bona fide and established practices of the trade. D. Which is of such nature as to deceive the public or cause confusion. In Info Edge, India, Private Limited and another versus Shailesh Gupta and another, 2002, 24, PTC 255, Del. The dispute was regarding the domain name, Naukri.com. The defendants had registered a similar domain name, Naukri.com. HC held that it is a well-settled legal position that when a person does business under a name sufficiently close to the name under which some person is already trading and the name has acquired a reputation, the public at large is likely to be deceived and misled. A. Which contains or comprises of any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India. F. Which comprises or contains scandalous or obscene matter. G. Whose use is prohibited under the Emblems and Names, Prevention of Improper Use, Act, 1950. H. Which consist exclusively of the shape of goods which results from the nature of the goods themselves or the shape of goods which is necessary to obtain a technical result or the shape which gives substantial value to the goods. However, if it is shown that before the making of the application, the trademark has in fact acquired a distinctive character as a result of use made of it or it is well-known trademark, then in such cases, the registration shall not be refused. B. Relative grounds for refusal of registration. Section 11 provides relative grounds for refusal of registration. 1. Confusing similarity with earlier trademark for similar goods, services. A trademark shall not be registered if there exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the earlier trademark because of a. its identity with an earlier trademark and similarity of goods or services covered by the trademark, or b. its similarity to an earlier trademark and the identity or similarity of the goods or services covered by the trademark. 2. identity or similarity with an earlier well-known trademark for goods or services which may not be similar. A trademark which is identical with or similar to an earlier trademark, and is to be registered for goods or services which are not similar to those for which the earlier trademark is registered in the name of a different proprietor, shall not be registered if the earlier trademark is a well-known trademark in India, and the use of the later mark without due course would take unfair advantage of or be detrimental to the distinctive character or repute of the earlier trademark. For example, in Bata India Limited vs. S. Pyrilal and Company. Air 1985 All. 242, the HC restrained the trade name, Bata, for mattresses, sofa cushions and other articles, though these goods were totally different from the goods manufactured by Bata India Limited. 3. Protection by law of passing off, copyright. A trademark shall not be registered if its use in India is liable to be prevented. A. By virtue of any law, in particular the law of passing off protecting an unregistered trademark used in the course of trade, or B. By virtue of law of copyright. But where the proprietor of the earlier trademark or other earlier right consents to the registration, in such case the registrar may register the mark under special circumstances under Section 12, Sec. 11, 3, and 4. Q. 10. What is the procedure for registration of a trademark? Uns. Section 18 to S24 deal with procedure of registration of trademarks. Section 18 lays down the following procedure for making the application and its acceptance. 1. Application for registration. A. Any person claiming to be the proprietor of a trademark used or purposed to be used by him, who is desirous of registering it, shall apply in writing to the registrar in the prescribed manner for the registration of his trademark. The application can be made in the name of an individual, partners or a firm, a corporation, any government department, trust or joint applicants. B. A single application may be made for registration of a trademark for different classes of goods and services, and fee payable therefore shall be in respect of each such class of goods or services. 2. Place of filing application. As per Section 18, 3. Every application shall be filed in the office of the Trademarks Registry within whose territorial limits the principal place of business in India, or in the case of joint applicants the principal place of business in India of the applicant whose name is first mentioned in the application as having a place of business in India is situated. Provided that where the applicant or any of the joint applicants does not carry on business in India, the application shall be filed in the office of the Trademarks Registry within whose territorial limits the place mentioned in the address for service in India as disclosed in the application is situated. 3. Acceptance or refusal of application. A. Registrar may refuse the application or may accept it absolutely or subject to such amendments, modifications, conditions or limitations, if any, as he may think fit. Section 18, 4. B. In the case of a refusal or conditional acceptance of an application, The registrar shall record in writing the grounds for such refusal or conditional acceptance and the materials used by him in arriving at his decision. Section 18(5). C. Withdrawal of acceptance. Section 19 lays down that, where after the acceptance of the application but before the registration of the trademark, the registrar is satisfied that I. The application has been accepted in error, or e. In the circumstances of the case, the trademark should not be registered. E. Or should be registered subject to conditions or limitations or to conditions additional to or different from the conditions or limitations subject to which the application has been accepted. The registrar may, after hearing the applicant if he so desires, withdraw the acceptance and proceed as if the application had not been accepted. 4. Advertisement of application. According to Section 20, when an application for registration of a trademark has been accepted whether absolutely or subject to conditions or limitations, the registrar shall cause the application to be advertised in the prescribed manner along with the conditions or limitations, if any, subject to which it has been accepted. 5. Opposition to registration. According to Section 21, I. Notice of opposition within 3 months from the date of the advertisement or re-advertisement of an application for registration or further maximum period of 1 month is allowed by the registrar. Any person may give notice in writing in the prescribed manner to the registrar of opposition to the registration. E. Counter statement by the applicant according to subsection 2. The registration shall serve a copy of the notice on the applicant for registration and within 2 months from the receipt of the notice. The applicant shall send his counter statement of the grounds on which he relies for his application. In case the applicant does not file his counter statement, he shall be deemed to have abandoned his application. E. Notice of counter statement to the opponent. Upon receipt of the counter statement, the registrar shall serve a copy thereof on the person giving notice of opposition. IV. Evidence and hearing of parties. Any evidence upon which the opponent and the applicant may rely shall be submitted in the prescribed manner and within the prescribed time to the registrar. And the registrar shall give an opportunity to them to be heard, if they so desire. V. Permit registration. After hearing the parties and considering the evidence, the ground of objections, the registrar shall decide whether the registration is to be permitted and if it is to be permitted subject to what conditions or limitations. 6. Certificate of registration. Section 23 makes it mandatory on the registrar to register the trademark where the procedure for registration of a trademark has been completed. Q. 11. What is the term of a registered trademark? Ans. The duration, renewal, removal and restoration of registration as provided under Section 25 is as under. Section 25 provides that the registration of trademarks shall be for a period of 10 years and is effective from the date of application. It can be further renewed for a further period of 10 years in the prescribed manner by paying the prescribed renewal fees. The trademark shall be removed from register if it is not renewed but can be restored if a request is made within 1 year from the date of expiry of registration or last renewal. Q. 12. What is infringement of a trademark? Ans. A registered trademark will be infringed if any person, in the course of trade of goods or services, uses the same trademark for his own goods or services without authority or uses a deceptively similar mark. In case of registered trademark, the holder of trademark shall be entitled to institute any proceeding to prevent or to recover damages for the infringement of a registered trademark. However, a person shall not be entitled to institute any proceeding to prevent, or to recover damages for the infringement of an unregistered trademark. For such person common law remedy of passing off action is maintainable. Essentials of infringement. 1. Mark identical, similar, goods, services also similar Section 29. 2, and 3. 1. A person who is not a registered proprietor or a permitted user but still in the course of trade uses a mark which is likely to cause confusion in public or is likely to have an association with the registered trademark because the mark is a. Identical to the registered trademark for the similar goods, services. B. Similar to the registered trademark for identical or similar goods. C. Identical with the registered trademark for identical goods, services. 2. Mark identical, similar, goods not similar. According to S. 29, 4. A person who is not a registered proprietor or a permitted user to use a trademark and in the course of trade uses a mark a. Identical or similar to the registered trademark. B. For the goods or services which are not similar and C. The registered trademark has reputation in India, and D. The use of mark without due cause. I. Takes unfair advantage of or is detrimental to. E. The distinctive character or reputation of the registered trademark. 3. Use of trade name. Section 29, 5, lays down that a registered trademark is infringed by a person if IV. He uses such registered trademark, as his trade name or part of his trade name, version or name or part of the name of his business concern dealing in goods or services in respect of which the trademark is registered. 4. Affixation on goods, packaging, business paper, import-export. 1. According to S. 29, 6. A registered trademark is infringed by who being no duly authorized uses the registered mark, if, in particular, he a. affixes it to goods or the packaging thereof, b. offers or exposes goods for sale, puts them on the market, or stocks them for those purposes under the registered trademark, or offers or supplies services under the registered trademark. C. Imports or exports goods under the mark, or D. Uses the registered trademark on business papers or in advertising. 2. Section 29, 7, lays down that a registered trademark is infringed by a person who applies such registered trademark to a material intended to be used for labeling or packaging goods as a business paper, or for advertising goods or services, provided such person, when he applied the mark, Newer had reason to believe that the application of the mark was not duly authorized by the proprietor or a licensee. 3. Section 29(8) lays down that a registered trademark is infringed by any advertising of that trademark if such advertising a. takes unfair advantage of and is contrary to honest practices in industrial or commercial matters, or b. is detrimental to its distinctive character, or c. is against the reputation of the trademark. 4. According to Section 29(9), where the distinctive elements of a registered trademark consist of or include words, the trademark may be infringed by the spoken use of those words as well as by their visual representation, and reference in this section to the use of a mark shall be construed accordingly. Q. 13. Under what circumstances there is no infringement of a registered trademark? Ans. Section 30 of the Act lays down certain acts and various circumstances where the use of an already registered trademark does not amount to infringement, and those are listed as under. According to S30. 1. The use of a registered trademark by any person for the purposes of identifying goods or services as those of the proprietor shall not be prevented by S29 provided the use a. is in accordance with honest practices in industrial or commercial matters, and b. is not to take unfair advantage of or be detrimental to the distinctive character or repute of the trademark. 2. A registered trademark is not infringed where a. the use is in relation to goods or services to indicate I. the kind, quality, quantity, intended purposes, value, geographical origin, e. the time of production of goods, e. or rendering of services, or iv. other characteristics of goods or services. b. the use of a trademark in a manner outside the scope of registration where the trademark is registered subject to any conditions or limitations. c. where a person uses the mark in relation to goods or services for which the registered owner had once applied the mark, and had not subsequently removed it or impliedly consented to its use. d. A trademark registered for any goods may be used in relation to parts and accessories to other goods or services, and such use is reasonably necessary and its effect is not likely to deceive as to the origin. a. The use of registered trademark, being one of two or more registered trademarks which are identical or similar, in exercise of the right to the use of that registered trademark. 3. There shall be no infringement where a person sells the goods in the market or otherwise deals with them when the person has lawfully acquired the goods with a registered trademark and for the reason that a. after the acquisition of those goods, the registered trademark has been assigned by the registered proprietor to some other person, or b. the goods have been put on the market under the registered trademark by the proprietor or with his consent. 4. However, where the condition of the goods has been changed or impaired after they have been put on the market where there exists legitimate reasons for the proprietor to oppose further dealing in the goods in particular, then provisions of subsection 3 shall not apply. Q. 14. What are the remedies for infringement or passing off a trademark? Ans. Following remedies are available for infringement of trademarks. 1. Civil remedies. 2. Criminal remedies. 3. Administrative remedies. 1. Civil remedies. A. Section 134 of the Trademarks Act, 1999 provides for filing of suits in the district court in whose jurisdiction the person instituting the suit resides at the time of instituting the suit for a. Infringement of a registered trademark or b. Any right in a registered trademark or c. For passing off arising out of the use of any trademark which is identical or deceptively similar, whether registered or unregistered. The suit may be instituted within 3 years of the infringement against the infringer or its agents or the company and its promoters and directors by 1. Proprietor, joint proprietor of the registered trademark or his legal heirs. 2. A registered user, a permitted user of a registered trademark. 3. An applicant for registration of a trademark. 4. A foreign proprietor when trademark is registered in India and infringement occurs in India. B. Section 27 of the Act further provides for action to prevent or to recover damages for infringement of registered trademarks. Section is couched in negative language and lays down that no person shall be entitled to institute any proceeding to prevent, or to recover damages for the infringement of an unregistered trademark. Section 27(2) also protects the rights of action against any person for passing off goods or services as the goods of another person or as services provided by another person, or the remedies in respect thereof. See Section 135 of the Trademarks Act, 1999, provides that the following reliefs may be claimed for infringement or passing off of the trademark. According to Sec. 135, 1. I. Injunction, subject to such terms, if any, as the court thinks fit, and e. Either damages or an account of profits, at the option of the plaintiff. E. The delivery of the infringing labels and marks for destruction or erasure. Criminal remedy. The trademark is a valuable intangible property and its unauthorized use can land the user in criminal proceedings as well as defined in Indian Penal Code. Civil and criminal. Both the remedies can be availed simultaneously as there is no bar to initiation of criminal proceedings, even if the recourse has been taken to civil proceedings. Administrative remedy. If a deceptively similar trademark has been registered, an application can be made to the Trademark Registry for removal of such trademark. Even at the time of registration of a trademark, an opposition petition can be filed to oppose the grant of a similar trademark which is already registered.